what happened today is that the Commonwealth, they filed a post-trial notice of disclosure claiming that they had been contacted by jurors. And so, Jarrett, I have some questions about this, about, if some of this stuff is normal, what a lot of this means.
None of it is normal. Let me answer that right now.
I know, and even calling it the mistrial, I mean the post mistrial, it's so crazy. But
I'll tell you what I don't like already. I don't like the fact that it's someone identifying themselves as a juror. It's all this like wonky language. It was a juror. Like, as prosecutors, if somebody calls your office, you could run down where that call came from. I don't like the way they wrote that. I mean, look,
okay,
they know if it's a juror, and they should have just said, we were contacted by jurors who provided identification and information only known to them. Like, it's a juror. Let's
right.
not play around here.
Okay, well, essentially, this is what it reads. I'm just going to kind of paraphrase it for a second. So on Sunday, July 21st, Assistant DA Adam Lally received an unsolicited voicemail on his office phone line from an individual who identified themselves as a juror by full name and seat number. And the individual stated, "It is true what has come out recently about the jury being unanimous on charges 1 and 3. On Friday, July 26, 2024, ADA Lally received another unsolicited voicemail on his office's phone line from the same individual who stated they can confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on manslaughter charges on the lower level manslaughter charges. The Commonwealth did not respond to this individual, as the Commonwealth is ethically prohibited from engaging in discussions about the jury's deliberative process." Now, let's just go through that for a second. I mean, did you hear that, Jarrett? 9-3 guilty on manslaughter. Holy moly.
So, look, that's how I saw this case from the beginning. I felt like, what does that mean, Lauren? It means that the jury, great majority of the jury, however, not unanimous, didn't buy the conspiracy theory. They just didn't buy it. Okay.
Right.
Now, those 3 that voted against a conviction on manslaughter, did they believe that the shoddy police work left something to be desired? Is that why? Were they not convinced beyond a reasonable doubt? Or did they basically believe the position of the defense, which was there was much more going on in the house, et cetera? So, look, I always thought this case was overcharged. The way it played out is not a typical intentional murder. I thought it was an overreach, even considering the text messages and the context, et cetera. So I believe that was a no-brainer. And then the leaving the scene of the accident, unanimously agreeing on that, that one is a little bit of a curveball. That basically means then maybe Karen didn't know she hit John O'Keefe and then left, but was acting recklessly prior to that in the way she backed up and didn't know he died. That could potentially explain that. But again, we're just reading tea leaves here. The most remarkable part of this is basically those phone messages. It's important that Lally notes they were unsolicited. He didn't reach out to those folks directly. They were compelled to reach out to him. He's very careful in dancing that ethical line about not wanting to discuss the deliberative process so as not to harm juries down the road. However, this is such unique territory because these messages confirm the defense's position that, in fact, Karen Reed was acquitted on count 1, and it looks like count 3. So this upcoming hearing, when is the next hearing on this issue?
August 9th.
So this hearing, this now is before the judge, and basically the goal now is to get the murder charge kicked and the leaving the scene charge potentially now kicked from the indictment. And then we may be going to retrial solely on the issue of manslaughter. So I think Lally views this filing as a saving grace, basically saying, hey, look, we had a great majority of this jury, which ultimately was hung on manslaughter. Let's move forward on the manslaughter charge. He's not saying that. He won't say that. Obviously, he wants to try to protect the entire information. But I think there's a good chance with this information coupled with the defense's position on these jury issues, you may see a retrial only on the charge of manslaughter, potentially.
Okay, well, that's what I was going to ask you. Do you think, because I'm thinking there's no way Judge Canoni is going to go with this, right? There's no way she's gonna knock off the 1 and 3. But now maybe she will. So there is a possibility that she will.
She has a great deal to think about. Now both sides are saying, look, jurors have said this. Judge, you got it wrong. Did you not inquire enough into the nature of their mistrial position? They're saying, we have a mistrial, we're hung, we're deadlocked, but on what charge? And by the way, a lot of this could have been the result of the difficulty of that jury verdict slip too.
Right.
So, and inevitably, we're going to end up in appeals court. This may delay the retrial because it's such a huge issue.
Yeah.
If the judge rules against the defense, they may try to seek an immediate interlocutory appeal because they're saying we cannot allow Karen Reed and her life, not life, but freedom hang in the balance now on an issue that's so critical. Clearly, the jury is speaking to us on this murder charge. Clearly, this instruction was wrong. Clearly, the judge doesn't want to overrule herself. We are seeking the involvement of a higher court. So any of those things is possible. We're back in Karen Reed land. I don't know what's likely to happen, but this is a tremendous development.
Right. And this does not look good for Judge Canoni moving forward in her career, I would imagine. This whole not reading all the verdicts out loud. I mean, and again, with the jury slip, I just feel like this is such a bad look. But am I being biased? Am I overreacting? Or do you agree with that?
Well, I don't know that it's going to detrimentally impact her ability to serve as a judge. It certainly doesn't paint her in a great light. But the reality is, I often say this, like, we're juggling grenades. A lot of things that go to a case-by-case situation. There's form instructions on things, but everything, in a sense, in this case, is unique. So I think the judge is going to be long-term okay. But she's made some missteps here and has been called out on them by a diligent defense. And this is proving to be the case now. Like I said, I'm not entirely comfortable with the way Lally wrote this. Like, it's like, oh, this all just happened upon them. It's like, look, you've been contacted by jurors who've acknowledged much of what the defense has claimed is now true. So we that's a lot to deal with.
Yeah. So then let me go into the second part of this. So then it goes on to say, similarly, the Commonwealth received emails from 3 individuals who identified themselves as jurors. These individuals indicated they wish to speak anonymously. On July 16th, 2024, the Commonwealth responded to the email stating that the Commonwealth would welcome the opportunity to discuss evidence or the Commonwealth's case. However, they're ethically prohibited from inquiring as to the substance of the jury deliberations. That would include your individual or the jury's collective thought process, content of deliberations, or reasons for your decisions. And then it was further explained that the Commonwealth could not promise confidentiality and that the substance of any communications may be disclosed to the defendant or the court. And then all 3 jurors declined to further communicate with the Commonwealth and provided no information about the jury's votes. Is that normal, where they say we can't promise that you'll remain anonymous?
Well, look, all that is all like, it's like, we'll talk to you. Here's a pile of dog shit reasons why you will not want to talk to us. It's like, we're really happy to talk to you. However, we can't protect your anonymity. We can't ask you about anything significant in the case.
Would you say that as a prosecutor?
Well, what they're saying is technically true. They can't, but again, they're playing with the language here. They can discuss certain things. They may not they certainly can't discuss that juror's personal position and other jurors' personal position. You could discuss the count. You could discuss whether or not ultimately they were unanimous on one or counts 1 and counts 3. So I don't know. I mean, what is the likely response to the way that's written? Who the hell would say, yeah, this sounds great, I'm in. Identify me. I can't talk about anything. So again, I don't love the way this is written at all. I think it could have been like, you could have confirmed that these people were jurors. You could have confirmed that there was an attempt to follow up. However, we provided them with a cautionary instruction that we could not guarantee that their identities would be protected. Here's the other thing. These folks can be subpoenaed. Just like in the Murdaugh case, a juror may now end up on the witness stand. And in Murdaugh, you will remember the statements of the clerk became a post-trial issue. And those
Right.
jurors were called back in to South Carolina. We can have that here. Whether the DA wants them or not, the defense can subpoena those folks. Obviously, they're bound by the fact that they cannot inquire into their deliberations and their particular vote. But there are certain procedural and factual inquiries you could make and still preserve the jury process. In my opinion, getting answers to these questions protects the jury process. Failing to get answers to some of these questions, to me, harms that process. It makes it look like we're more worried about protecting the confidentiality than getting to the truth here.
That is, you said that so beautifully. That's what it seemed like to me. And I could not verbalize that. So thank you. It really seems like they don't care about the truth. That's what it reads to me. And yeah, sometimes, sometimes I think that maybe I do have a little bias here. I know where I stand. And so I'm reading this in that lens. But you saying all this makes me feel a lot better that maybe I'm not so biased after all. But
Well, and I'm not necessarily biased. I'm just seeing it how
no,
people
you're
are going
not.
to
That's the whole point. You're not biased. I'm saying
right.
I
And
am.
I think people are going to see it this way. It's like, geez, we want to know, we want answers to these questions. Certainly, Karen Reed, if she was legitimately acquitted of the charge of murder, that inquiry needs to be made, and a real assessment needs to be made as to whether or not that charge should go forward. Period.
Yeah.
The DA should consider that. The judge should consider that. Ultimately, I don't know where they're going to come down, but man, you can't ignore this. You cannot ignore this. And they're on the same page. And it proves what the defense has been saying for the past several weeks.
And I'm just going to say this. I feel like they have a better shot of a conviction, clearly, if it's 9-3 and you just go into the January trial and say, yeah, you're charged with aggravated manslaughter. I mean, I don't know why they wouldn't drop those two charges.
Well, I'm telling you, I believe it was an overreach. I've been in situations where cases have been overcharged and, you're grasping at straws. I just think they need to very seriously consider pursuing that particular charge. And again, we've said it. We have a dead police officer. We have a mourning family. We have a high profile public pressure case that's politically charged. I don't know ultimately what they're going to do. But this is another significant development in a long road of crazy Karen Reed shit.
I'm really glad that we jumped on to discuss this. Things are a bit clearer for me now. So I'm glad that, you could lay it all out there for us. Thank you so much, Jarrett. And hopefully, is next week the 9th? No, yeah, it is. So it is. It's next week. And I believe it's at 2 p.m., these arguments. I'm so anxious to hear them.
Well, we'll be discussing them. And if anything breaks in the meantime, we'll be on top of it.
Definitely. All right, guys. Have a good one.